Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 fundamental questions in this series, and today we are talking about the 4th question, which is holding interest in property. And we're dealing today with the ways in which a tenant may exit a leasehold arrangement. As we discussed in the video on subleases and assignments, a tenant may try to exit a lease in an orderly fashion by transferring her interest to someone else. Or alternatively, a tenant may simply abruptly leave or tell the landlord they're breaking their lease and may never be heard from again. The question is, what obligations are imposed on the landlord in that alternate scenario? So that brings us to the 1977 New Jersey case, Sommer versus Kridel. Kridel signed a 2-year lease for an apartment, but unfortunately he had a really bad year. His fiancée left him and he was a student with no money. He notified the landlord, Sommer, that he would be unable to take possession of the apartment he had planned to lease. He begged Sommer for understanding and compassion. But instead of understanding and compassion, Sommer sued Kridel for over $7,000, the full amount due under the 2-year lease. Sommer didn't do much else to recoup this missed rent. In fact, he failed to lease the apartment to people who were interested in it immediately after Kridel decided not to take it. After that, Sommer waited 15 months to show the apartment over halfway through the lease term. In viewing these facts, the court was unsympathetic to the landlord. The court found that the landlord should have tried to mitigate the damages that resulted from Kridel not taking the lease. The reason this case is important is because it upended the traditional rule on point. The traditional rule was based in property law principles as opposed to contract law principles. It held that a property interest had been created in the tenant by the lease, and no matter what, the landlord couldn't interfere with it. And so the landlord could just sit there and wait until the end of the lease and recoup from the tenant all damages. This New Jersey court, however, decided to apply contract principles to the issue. Contract law requires parties to be responsible and reasonable. There is a classic contract law duty to mitigate when the other party breaches. This court imposed a duty to mitigate, as well as a duty on the landlord to prove that he was reasonably diligent in mitigating damages. As a landlord, you could prove this by showing the apartment to people, putting out ads for it, and doing other things that show that you actually want to rent the unit. On the other hand, it's important to note that the landlord doesn't have to accept below market rents just to mitigate. And importantly, tenants will still have liability for any costs associated with finding a replacement tenant and for any difference between the rent they were supposed to pay in the contract and the rent that the landlord actually received from any tenants that took up the lease. So the duty to mitigate has been another one of those default rules which the vast majority of states have adopted. Note that while it is a default rule, parties can typically contract around it. California says that in the rare circumstances where landlords don't have a duty to mitigate, the landlord must allow the tenant to transfer their interests liberally. In other words, the landlord would have to allow subleasing or assignments discussed in another video. The truth is that even without this rule, the landlord would have an incentive to mitigate, even without a duty. A tenant like Kridel might be judgment proof. So what that means, he didn't have a lot of money. He may never have been able to produce the more than $7,000 that the landlord asked for. It's also possible that tenants will leave the jurisdiction or be very difficult to track down. Also, lawsuits cost money. Taking matters all the way to a state Supreme Court, as happened in this case, is very costly. So again, landlords may have the incentive to mitigate damages even if they don't have a duty. So with that, I'll leave it there. I'd love to hear from you on Twitter or through my website where you can sign up to my mailing list. See you next time.